Let's start with the most basic thing. When we talk about intellectual property, what are we talking about? Well, we're talking about basically things that come out of your mind. So, tangible property is your laptop, your clothing, your car. That's tangible, real estate. Intangibles are things that come out of your head. And those are all examples. It could be a trademark, it could be music, you'd write a new book, it could be a piece of software, it could be a new research invention, a new way of doing business. Almost anything that comes out of your head is potentially intellectual property. And the area of law, intellectual property law, deals with what can be protected by law, what can't be. Lots and lots of intellectual property is not protected. That is actually a difficult area. In the patent area, for example, the Supreme Court has heard a number of cases over the last 5 years deciding where the dividing line is. And every time they decide one of these cases, no one has any idea where it is. They granted cert on this year for another case in that area. And it's still somewhat of an open question exactly where the line is. But for purpose of the introductions, understand that anything that comes out of your head is potentially intellectual property. It's not illegally protectable, though. There are limits on what can be protected. And just, real quick historical perspective. As I said before, there's an old area of law. When the Founding Fathers wrote the Constitution, they put the patent and copyright clause in the Constitution, and it said Congress can enact IP laws. They probably did it in 1790. The first patent law and the first copyright law were enacted immediately. This was considered something very important. And just by way of international history, those bodies of law go back to the 1500s. It's not a new area of law. It's been around a long time.